Hello, everybody. Sorry I'm late. I was like, I gotta get coffee and I gotta pee real quick. And I was like, 5 minutes is more than enough time. Yeah, well, it wasn't. Hello, Emily. Hello, Tammy. Starting off strong with the reminders. Hello, Philip Hill from the Mali, Victoria, Australia. Hi, Lucy. Hello, Brian Boggs. I am sorry. I'm sorry that your day has been horrid. I hope I can make you laugh. At the very least, I'm going to frustrate the heck out of you with some of these people. Hold on, I got to try to shift up. I'll tell you what, this desk has been like the greatest lifesaver. Seriously. Like having the U shape, me being able to drape my leg over so that it's above my heart. It's the perfect height. And like when I have to shift, I can just put my arm behind and like prop myself up. Palmy, you did me right. Oh, honey, we love you any way we get you. Crabby, sad, grumpy. Don't matter. Jovial, as you say. We love you anyhow that we get you. Hi, Foxtrot. I'm sorry. Did you not get the Discord notice either? They always put them up in the Discord. Well, April had to pee. and April needed coffee. It's actually a pot of Wake the Hell Up. It really is. Because it's got the best flavor. You know, caffeine intake aside, it's got the best flavor. I love it. I have to be very careful with it, though. I wish I could get that flavor without the triple caffeine, to be honest. Hi, Shane. Thank you for that. Hi, Jenny Green. Hi, crazy old lady, my love. I love my pre-chats. Hi, Rocky Lennon. You're not late at all, because I was. Hi, Catherine Gaston. That is wonderful news. I am so happy to hear that. Hi, Tiana Miller. Good to have you, sweetie. Oh, yeah. So, and then I've got a pupper in the bed right behind me, snoozing along comfortably. pretty much as always. The Wake the Hell Up. Yeah, the only place I've ever heard of it was Amazon, and that's only because of you guys. You guys have been amazing with keeping me well supplied with that. But like I said, I go sparingly on it because, for one, I don't want to run out because it's my favorite. But for two, I'm afraid of the consequences. Like, triple caffeine on every cup cannot be good for me. I'll take my chances, though. She's really great about those, isn't she? We had a really awesome members-only stream last night, which, pretty much everybody that hangs out here is a member, even on the replay crew for the most part. Oh my golly. My brother had an ulcer at 16. He was fresh with his driver's license, and I remember him doubled over in pain from drinking that. Yep. It was caused from that. That was awful. Yeah. But he drank a lot of it. So, he actually called me tonight, and was telling me about, he found some photos of mom and grandma and, a lot of family history photos and stuff. And, he's been in contact with some other family members, and, one of the things that he found was, I think he said it was from 1944, and it was a letter from the military, and it was addressed to a family member that and then there was another letter with it that was addressed to that family member's mother, who is the mom of my mom's cousin. And it was just like, I know how it ended up like getting all in with the other family photos and stuff, but it was just, to find it was wild. And so he contacted the family member who, it was her, the handwritten letter was to her mother from her dad, and he's giving it to her because, who's going to appreciate it more, it was just like going through a house of 6 generations after someone has passed. It's crazy. And then we were talking about, stuff, and I'm like, I don't really want anything. The only thing I really want is a baby photo of my mom that I remember from when I was a kid. And I started describing it, and he goes, wait a minute. And he sent me a picture message, and he has it. He thinks he might have another original copy. So he's going to get that to me. So that was really cool too. Yeah, that's exactly what that was. They were about the same time as Jinkos. Actually, I think Jinkos came a little bit later. A little bit. Just a wee bit. But yeah. No, it was really cool getting that call from him. And then he's like, so he had sent me a voicemail that his wife had on her phone. And at the end of the voicemail, my mom says, I love you too. And he was like, yeah, I'd really like to, figure out how to take that somewhere and get it edited. And I'm like, dude, you realize you have a sister who, has a YouTube channel and she has to edit all of her own content, right? So, yeah, I'll be doing that. I was planning on it anyways, but yeah, absolutely. I don't know the whole story, but I really hope what you're going through, I hope everything gets better. You can hear Earl saying he hopes everything gets better too. Right, Earl? Right? Right, Earl? I think Brian Boggs needs a cat tax. Come on, Earl. Come on. Earl. Come on. Come say hi to Brian. Or lay down. Same thing, right? It's the same thing. You're going to say hi to Brian? Say hi, Brian Boggs. Oh, and Billy says hi, Brian Boggs. Look at this. Look at this. The whole paw firm. Here for Brian. Aww. Aww. Look at this. We got an Ava and a Billy and an Earl. All here at the same time. Billy trying to steal the whole dang show. Yes. Yeah. You trying to steal the whole dang show. Yeah. Aww. I take it you want treats? Is that what you're here for? Yeah? I gotta reach your drawer. Well, I'll get these out for the kitties for after you. There we go. But you got to come around this side. It's a good girl. And you got to be gentle. Be gentle. It's a good girl. Gentle. Aw, who's a beautiful puppers? Who's a sweet little angel? It's you. It's you. Can I boop the snoot? Hold up. Wait. Boop. Hi, Earl. I see you. Here you go. Good, gentle, good girl. That was a very good girl. And I know you probably can't see it, but Billy is right here. Yeah. He being a good love. He being a good love. No, I'll put those away in a minute. Nah, you get up for this. Yeah. Earl had one earlier. Billy did not. Oh. I can feel you with your head on my knee, Ava. It's cute and it's hilarious. You just spilled. I love the face he makes. He looks so grumpy. I'm moving my keyboard. I don't trust you. I don't trust you. Oh, that's why I moved it. Here, Earl, you want a lick? Earl. No? Yeah? 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 Aww, my boys. Oh my gosh, they're so cute. They are so stinking cute. Hold up, hold up, hold up. Okay, okay, here. This stream is not sponsored by Temptations. Oh, I love my babies. All right, there's your treats. I gotta wash my hands here. There, cat tax, dog tax, all the taxes are paid, other than the gov. The government. The government. I wish I could find. I think that was the Knox County judge, and they don't stream anymore, which I miss them. I miss them. The government. All right, boys. You good? Can I wipe my desk down now? Piggies. All right. Oh, Billy, you missed this. Get this. Earl, you want to get this? There's a little drop, like the size of a pea. Come on, you want it or not? I will wipe it up. I'll do it. It's salmon flavored. It's right here, doofus. Yeah, that one. Good boy. I always heard it with a B. Government. All right. Thank you. Come again. Yes. Yes. Mama's going to stream now. Goodbye. Goodbye. I love you. I love you. Okay. All right. Now that all of the animals are fat and happy, and it's not just me. Well, hello again. Okay, now what? What now? What now? What now, baby girl? You got yours. I hear that sniffer going a mile a minute. I know, you didn't get a bacon one. Gee whiz. You think I can get away with anything around here? Anything. Whoa, hey, quit it. All right, I got the bacon one out. Come on. Come on. Ava. Come on. Wait. Wait. You've got the prettiest eyes. And then we got Earl perched up in his box. He got sick on my bed today. So Kendra and her boyfriend had to come in and change my sheets out for me. Yep. It's her cat. She should have to anyways. Well, you gonna be a cuddle buddy now? You gonna be Mama's cuddle baby? I love you. All right. This is hilarious. Oh, this is hilarious. I every time I go to start the clip, she jumps back up. Yeah, she just wants love. She just wants love, yes. Am I ever going to get to start the clip? Or is that not a thing anymore? We're no longer a court channel. We're just a paw firm. Now what you sniffing for? There is nothing left to sniff. Nothing. I cleaned the desk and everything. Aww. Oh, that was sweet. I love her. Hi, sweetie. Of course she is. She's been here for a minute. She got her treats, and now she's just giving extra loves. Extra loves. See, when y'all do this, and I don't even know what that says. When y'all do this, I don't know what it says, and I can't look it up. Oh, she's so sweet. I can't look it up, and I can't put it up there because I don't know what it says. For all I know, you're probably calling me like a fart sniffer or something. I'm so sorry, Foxtrot. Oh my gosh, she is extra balls of love tonight. Yes. She is extra lovey. Yeah. I think she knows. My foot hurts. You don't have to, honey. I'm picking on you guys. Hi, dolphins. Good to see you. Ava, it's Auntie Dolphins. Auntie Dolphins. Here, I gotta get you a treat from Auntie Dolphins, Ava. Ava. Oh, wait. Auntie Dolphins is here. Yeah. She misses you. I know she does. She misses you. You're so pretty. Yeah. You guys can speak it all you want in the chat. Absolutely. I'll never tell you not to. I just have absolutely no idea what you're saying. I do think it is beautiful. It's gonna be a minute. You got plenty of time to learn. Hi. Good to see you, Salty Buddha. Oh, yes. Did you hear me saying hi to Salty? I do that all the time with Spanish. It's amazing how much it gets wrong. Like, and you know it's wrong, and there's nothing you can do to correct it because you have no idea how to say it right. Yeah, me too. Slap, 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 slap. You want to lay down now? You can lay down now. Good girl. Good girl. I see you. I see you. They can kind of see you peeking up over my leg. Oh, you're a good girl. You're going to cuddle with me all night, aren't you? Why? Who's here? All right, let me see if Ava's going to allow me. Let's see if she allows me. You are shedding everywhere. I think my pants have more fur on them than you have on you. All right, let's go with...
This is State of Michigan versus Tavion Calhoun, case 2405604-201. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
Good morning, Judge. Again, always a privilege. Steve Benson for the people, P71917.
Once again, Your Honor, Philip Reagan on behalf of Mr. Calhoun, way up, well, Judge. He's here for bond redetermination.
All right, thank you, gentlemen. Mr. Calhoun, sir, could you state your name for the record, please?
Tavion Devontae Calhoun.
All right, thank you, Mr. Calhoun. Today is the date set for a bond redetermination hearing. Bond is set as an intentionally unaffordable cash bond at this point. Mr. Reagan, as to bond.
Judge, Mr. Calhoun is 29, does have some previous convictions, Judge, does have a prior home invasion and retail fraud. I just want to be honest about that. He just got his probation reinstated the other day, Judge, for operating while intoxicated case. So he got that reinstated, so he's on probation, receives SSI, doesn't have any children, Judge, lives in the Metro Detroit area. Obviously, Judge, the home invasion case, it's a serious case. The bond is $30,000, Judge. I think that if you have no contact, you have a tether, and you have house arrest because there's no work here. Mr. Calhoun's not working, so he doesn't need to leave the house. I think a less restrictive measure other than incarceration could be, Judge, in this case, a personal bond with the tether and the house arrest, complete house arrest, Judge. He understands he's not to have contact, go back to the location where these alleged incidents occurred. But again, they are still allegations, Your Honor.
All right, Mr. Vincent.
Judge, well, let's be super honest with you here. The defendant's on probation right now for 2 different offenses. For that OWI offense that he had already spent jail on, as well as a drug offense. that he ended up pleading to, which is still active. Actually, Judge, within the last year and a half, he's been convicted of 5 offenses, 4 of which he's ended up spending jail time on. And I actually added them all up and divided by 4, average of 62 days in jail for each one of those offenses. And then, Judge, by the way, within the last month, he ended up pleading to an assault that was pled down to from a robbery, as well as a fleeing and eluding from Toledo, Ohio. And at sentencing, he failed to appear. So on top of the dangerous component that we have here, we have a flight risk. And I'm sure Your Honor ended up reading the allegations. We have an address from this individual in Ohio. We have an address here in Michigan. I mean, he's just on a spree, with all due respect, Judge. Within a year and a half, he has 5 convictions, and he pleaded to fail to appear on. Judge, I mean, what you and I and everybody else look at is a robbery charge being one of the highest offenses that you can be charged with, let alone being convicted of. And then, Judge, we have the allegations of an individual who, let himself into a house that wasn't his. There's a young girl who's scared. There's a mom who's scared. He doesn't belong there. And then, there's gasoline or whatever it is that they were talking about in the investigations, Judge. I mean, clearly he's a danger. I'm going to ask for a cash bond, Judge. I just think that at the present time, he poses a danger to this community, maybe to other communities, because allegedly he's committed crimes there where he's pled to. So respectfully, Judge, we're just going to ask you to continue this.
Judge, he's got the cash bond. Just briefly, Judge, I'm hearing what Mr. Vincent said. I don't know anything about robberies or anything like that, but I do know that this, obviously is serious. And I think that the court with the tether and house arrest could solve that issue. Yes, he has priors. He's receiving SSI. He's back on probation, so he's being monitored by the probation department as well. And they have certain conditions that he has to abide by. If he doesn't, he violates that and goes to jail. But I think right now, Judge, with the tether and house arrest, you could make sure that he doesn't go back to that location, nor to any other location, because house arrest means you stay in the house. You don't get a chance to get out and drive or walk to the store. You don't get those options when you're on house arrest, Judge.
And Judge, I know you don't
sorry,
like
no, Mr. Vincent.
Sorry.
Stop.
Sorry.
I'm looking at previous history as well as the allegations that were set forth in this. And Mr. Vincent, you called this a robbery. But it looks like, at least according to the allegations, the defendant had a specific purpose of coming to that house. It was alleged that he was asking for his mail. Then it's alleged that at some point after the complainant, fear for her safety and the safety of her child, locks herself in a bedroom, realizes that someone is in that house, and possibly did something to the gas to cause her eyes to water. I'm not convinced that a non-cash effort would prevent Mr. Calhoun from coming back to that address. And this, on top of that, it sounds like there has been at least an occasion where the defendant missed a sentencing on a felony matter in a different jurisdiction. I am inclined to keep the bond where it's at. I believe that there's preponderance of evidence that the defendant is a flight risk in this situation, and I don't believe that a non-cash restriction would prevent him from not showing up to court. So I'm going to keep
Yeah, I agree, Judge.
the bond where it's at this point.
Thank you, Judge. And I just have to let you know this, and I apologize. I may have confused you. The robbery and fleeing and eluding, that was the Toledo, Ohio incident.
Oh,
that was one that he just ended up, he just pled to that one, but he failed to appear at sentencing. I didn't mean to misrepresent to this court that there was a robbery that took place here. This is the home invasion. You're absolutely
I did. So he pled on a robbery in Ohio?
And the funny thing was, and I know Mr. Reagan, and I take him at his word, even though it's kind of, I don't know, how to take this. I tried to tell him about this yesterday, in regards to these cases. I think he was busy. He was juggling the felony arraignments.
Mr. Benson, I'm sorry to cut you off, but did he plead to the robbery in Ohio, or is that just the original charge and pled to the fleeing and eluding?
No, he ended up, the original charge was robbery. It got pled down to an assault, but then he had a fleeing and eluding charge on top of that he ended up pleading to. So he pled on the nose to the fleeing and eluding, and then the robbery got pled down to an assault. And then he was on a cash bond, but then he pled, so it was converted to a personal, and then he failed to appear at sentencing.
I'm sorry, everyone. That's enough. Let me give you guys the next date.
Okay.
Oh, I just wanted to clear that up. Sorry.
That's the one thing with this judge versus McConico, because this is actually McConico's personal meeting room, and he'll come later, but this Judge Williams, won't let these two go on forever. Judge McConico, I think he enjoys watching the banter between these two. And these guys, they're so much like brothers, just back and forth. And it's very entertaining to watch. But this judge actually just cuts them off. He's like, nope, you're done. I'm done. I got my ruling already.
Even though I don't.
Judge Williams.
Yes, sir.
Yeah, Judge Williams. I feel that I'm not a flight risk. I'm not a flight risk. Like I just wanted to leave on at least tether or get a personal bond, because I do have another case out in Toledo. I didn't make the case in Toledo because I didn't get my mail and my ID. They wouldn't let me leave Michigan. Well, I couldn't leave Michigan without getting my check and stuff to go back to Toledo. So
that's one of the issues with this case, Judge. His mail was going to that address.
Yeah, my mail was going to that address, and that was my whole thing about going to that address.
Judge,
So both of you.
Right.
I made my ruling. That's it.
Okay. Thank you, Judge.
Let me get you the next day.
Thank you, Judge.
Attorney Reagan.
Yep, hold on one second.
Okay, Mr. Calhoun, your next date is a probable cause conference, March 15th, 2024, before Judge Sabri. And then that's followed by a preliminary exam, March 22nd, before Judge Sabri as well. All right, and that concludes this hearing.
Thank you, Judge.
Calhoun. Mr. Perkins, I'm just gonna come upstairs for a second, and they can bring Mr. Jackson.
Okay.
Okay, thank you very much, Mr. Calhoun. Your lawyer's gonna be able to come see you shortly, okay?
Yes.
Okay.
Yeah, Reagan. I was wondering, why couldn't I get?
We're still on YouTube.
Can put me in a breakout real quick, Marcia.
Oh, I can't. Judge Williams got didn't make
okay.
it go.
I'm gonna try to come down. Hold on. You're not co-host? Okay.
No, Judge Williams took it.
Okay. Can you cut the YouTube off?
Oh, I can't do nothing because he the host.
Okay. Well, let's start this. I'm gonna try to come down.
Now, I promise, just trust me on this. There's some dead space that I did not cut out. Just trust me. Let's go for this little ride because you're going to enjoy it.
Hey, how you guys doing? Hey, Marcy, how you doing? Well, you guys can sit down. It's all good. Okay. Is he talking with The last person in the breakout room?
Yeah.
Okay. And is Jackson in that same jail?
But it worked for some. It worked for some.
Yeah, I'll be right back. I gotta go cover some other cases. But I'll be back in 10 minutes. I gotta cover other cases. No problem. He's still talking with the last gentleman, so they got the camera.
Oh, okay. Wow. Actually, 6 months for a sense of this. Not relying on judge that may have motive. Not motive, well, I'm not saying anything, but when you do your voir dire, the best of your ability, you're counting on those individuals because you picked them, and now it's all you. Now it's all you, or it's all me. It's all the story. It's so pure. It's the story. It's so pure. So, oh.
Yeah, okay.
Yeah, I think Judge, I don't know if you were on the phone or not, he said like 10 minutes.
I heard that part. I'm talking about,
Okay.
man, you still want to talk to me? Went in, come.
I don't know, because I'm surprised that Ohio didn't come back. Oh, is that how it works?
So let me drop this.
Yeah.
Tell my man Calhoun waiting to talk to me.
Which one? Oh, this one? This one? No, the land.
What's up, brother Calhoun?
Yeah.
He seriously cried, if that's what you call it, and then looked up to check, are they looking at me? Oh, they're not? Okay, I give up for now. And a little while later, he tried it again. And because they weren't looking at him, he gave up. Like, okay, the whole crying bit only works if, one, it's genuine. And if it's not genuine, you can't check to see if they're looking at you. Yeah. Yeah, that was so funny. Oh my gosh. And it gets funnier.
Mr. Reagan, man, they saying that I broke into the house. I
didn't break in the house. You went to get the mail.
yeah.
It was all yes.
Yeah, I'm about to put you in the breakout room.
Okay, I understand, good brother.
Yeah, and they said I broke into the house and I was running around trying to
Hey,
find.
Phil, you know, I can hear all of this, Phil.
I'm putting them in the breakout room. Hold on.
So inappropriate.
Go score my mail. Oh, okay, cool. But the
Don't
judge
take
stepped
offense to
away.
that. I'm just doing that for you for your case.
The
Just
judge
wait
stepped away
for your lawyer.
But I'm gonna let you in. So as soon as the judge stuff comes back, okay, because he has retained counsel. Okay.
man.
Kill.
Hey, yo, right here. Hey, right here. He trying to
Yeah, be reasonable. I know where you're going.
It's not over.
See, I think he's either just waving away or he's trying to get yours.
Me? Yes, yes.
I was trying to see if I was gonna talk to my lawyer.
I mean, I could go into outside the hall.
Zoom in.
Yeah.
I'll put you in the breakout room.
Yeah.
Okay, he's gonna go in the hallway and zoom in, cause he's actually in the courtroom. Then I'll put you guys in the breakout room.
There you go.
I'm supposed to stay in Ohio to the 28th, and to the 28th. But I left Ohio on the 19th because I didn't have no cash. You know, you gotta pay to get around in Ohio. They don't got regular transportation in Ohio like Michigan. So I came from Ohio, I came to Michigan to pick up my check to go back to Ohio. When I arrived at the address, there was no mail in the mailbox. There was somebody walking around the house. And I got my check on first. I swear to God, man, I swear to God on my mom, on my dad's grave.
This defendant and that public defender sure wants prosecution to hear his story very inappropriately. Like, I've never seen this. And I turned the audio up just slightly so y'all could hear what he was saying a little better, but I did not enhance it very much. Like most stuff I have to enhance at a minimum like 9, usually more in the range of like 11 to 15 when I do audio enhancement. I only had to turn his up to like 4.5 ish. So yeah, he's telling his whole story and he knows they can hear it. And he's talking so loud, like he wants prosecution to hear it. And that was twice prior to this that his public defender was not only letting him talk about his case, but almost encouraging it. I'm baffled by this. I'm baffled by this one.
Well, and so right, how I get to find out is the. All right. All right. Thank you. He said, you going to on the market for all. You won't work with it. That shit wrong, but that is just saying that I chased into a little girl. And that was something in the house. You know that. Police would have said that. They tried to get her back and forth. They looking around the house. There's mud all around the house. I got a big ass roof. If I even set foot in the house, there was mud in the house. Everywhere. So where the evidence that I was running my house? And they said I kicked the dog. Where's the wood and the nails and shit? Why? That's the storm though. Yeah, you know
Okay, I'm inside one. Tomorrow in third, no, I'm in 12. No, he came from Miami. That's why I asked for the mask. Like he been doing that since we was. They say connect them to audio. I don't know what it's doing, but it's still in court though.
Todd, I'm gonna put you in breakout room number 2.
Okay, thank you.
Mr. Jackson, you're gonna see something that says join breakout room number 2. You're gonna click it.
There you go.
Just let me know. Just let me know and pull me out of the breakout room when the judge gets in. I'm ready to go.
Okay. Click the little link. It says, you should have came up on here. There you go.
I respect it though. Mr. Perkins just likes to be in court.
Cindy Hamilton.
Oh, you got him?
Yeah.
She hooked you up?
No, she actually.
That was fast.
What happened?
I hit the wrong button.
Okay, I'll do it again. Okay, I'm gonna send y'all to, I'm gonna send you to 3.
Okay.
What time we start? 7:30? Hey, bro. Might be something.
Mr. Vincent.
See everybody. Mr. Jackson, can you hear me?
Yes.
All right, this is State of Michigan versus Robert Jackson, case 24055-75101. Today is the date set for a bond redetermination hearing. Can I have appearances, please?
It's good to see you in person. Steve
Good to see you too, Mr. Vincent.
Yes, sir. Yes.
Likewise, Your Honor. May it please the Honorable Court. My name is Todd Mr. Perkins, P 55623, appearing on behalf of Mr. Jackson. Mr. Jackson, can you state your name?
Robert Jackson.
All right, good morning, Mr. Perkins. Good to see you as well, and good to see you, Mr. Jackson. Today is the date set for the redetermination hearing. Bond was set intentionally unaffordable. Mr. Perkins, as this is the redetermination hearing, I'm going to let you address bond.
Thank you. Your Honor, I did everything I could to for Judge Compare not to issue a remand, which was, I think, initially sought. And you know, one of the things that I was able to receive from Brother Counsel, but not the lawyer that was arguing for the people on that day, is Brother Counsel enlightened me to the fact that if you look at, I didn't have the 3rd page of the investigator's report. It says the witnesses did not wish to be involved and refused to give statements. So that's most of them. Now the statement I have to indicate that I have had an opportunity to at least get paper discovery. Notwithstanding that, Brother Counsel was ready to give me what he had, which is a statement. It's quite different than what you read in the investigator's report. And I'm not here to litigate the case, but I am here to give you a likelihood of conviction. And I think it's far less than what was opined by the government the other day. In this case, in the investigator's report, it says Robert Jackson shot this car out. Robert Jackson had a gun to me. In his own written statement, he never indicates that Robert Jackson ever had a weapon. He indicates that there are multiple people that chased him. Quite different than what the investigator's report, which is a summary But so what that judge had, what Judge Compare had before him is different than what you have before you. But more importantly, and I don't think that Judge Compare took note, or he did acknowledge this, but no one can get over the fact that oftentimes an individual being on supervised release with the federal court system is not a good thing. In this situation, it is. In this situation, Mr. Jackson is tethered. He was on a weekend at the time, and I look at it, and if I may approach, Your Honor, I have shown Brother Counsel this. If I may approach him. Oh, sorry. No, that's.
Anybody else see that table just jump out at him? I saw it. The details of this are just bizarre. They really are. And it leaves you really unsure about everything. I have a few theories on what's going on, but even after seeing this one, I have no idea.
It's two separate items. Two separate items, and what you're looking at, Your Honor, is his tracking. He's tethered. He's got a GPS tether, and if it indicates there, it says between 5'6" and 5'8", there's nothing. So I contacted his federal supervisor release probation officer, and I asked Agent Glaros, well, why doesn't it say anything? Well, she responded with, she contacted someone else who directly monitors him. And he's at home. He's at that Sterling Heights address throughout 5'6" to 5'8" and does not move until 5'8" at that particular time. That's why he has, and I indicated, and jokingly, we were talking off the record before this, at the inception, even at the arraignment, I have an ironclad alibi in which I'm going to bring a federal agent and officer and monitoring officer for the purposes of any proceeding if this continues to support the fact it's not Robert Jackson in this particular matter. More importantly, well, just as important, Your Honor, this is an event that happened on May 7th of 2023. Mr. Jackson is currently employed. He's missing employment. He works for Amazon. He's a delivery for a person for Amazon, has license. He's continued to stay up on his probation requirements. He has the child in common that's alleged in this particular matter actually lives permanently in full custody with Mr. Jackson. So in this situation, what I surmise is that this complaining witness, I'm not here to say that this complaining witness didn't get hurt. I'm not here to say that. What I'm here to say is this is a supposition that he's made. He didn't identify Mr. Jackson, which is clear by that. So what is my ask, Your Honor? I'm not coming in here asking you for a recognizance bond. I think the charges are too serious. I think Mr. Jackson has too much prior criminal history, but I think $200,000, it's declared to be intentionally unaffordable. But it's declared to give is for this purpose that you stand, and with the information that you now have before you, that I think it's different from what Compare had. And I just don't think Judge Compare looked at the validity and the veracity of what's before. The other attorney is saying, well, I've seen people get around that before. I think that's inappropriate to say that without having the basis to be able to do that. And so what I'm asking, Your Honor, is I don't believe, because he's working for Amazon. He can't work for Amazon with the tether. So I'm asking, Your Honor, a deletion of the tether, and I'm asking for a 10% bond of the $200,000, which is a substantial amount of money. So I believe reasonableness should dictate this process. I'm not asking you to be unreasonable, but I'm asking for those accommodations, Your Honor.
1 second, Mr. Perkins. I'm sorry. All right, Mr. Perkins, and I would note these are de novo hearings, and I'm gonna get to you, Mr. Vincent, because I gotta fill in some gaps here. You indicated that your client is on a tether through a federal case?
No. It was ordered that he have tether as a condition of his bond in this case. I'm asking for the deletion of that particular order.
Well, you said he's on a monitoring under a different circumstance.
No.
What is it that you gave
No,
him?
Judge Compare ordered a tether. And I'm asking, and what I'm asking in the reconsideration is the deletion of that tethering.
Well, I think you misunderstood my question, or maybe I'm not explaining it right. You
Oh.
gave me a document.
I do understand now.
Yeah, what is this?
That is back in early parts of 2023. He was on a GPS device at that particular time.
Okay.
And so he worked himself off of that, and now he's been released and he doesn't have a tether.
Was that as a condition of some sort of probation?
Yeah, he's on federal supervised release, federal probation. They call it supervised release in the feds, we call it probation in the state.
Yeah. And what is that for?
Narcotics offense from a marijuana offense, unfortunately, from, I want to say 2014 or 2000.
Okay.
2012.
All right. You indicated that you did not have the third page of the investigator's report at the time of the original arraignment. I'm looking over my information. I do have the third page.
Right.
They have a witness list, which includes one of the complaining witnesses, Graves.
Correct.
And you indicated that there was a statement by Mr. Graves that is different than what purports to be in the investigator's report?
Yes, in the investigator's report, it indicates, Your Honor, that that Mr. Graves says that Mr. Jackson shot out his window, that Mr. Jackson was the one that hit him upside his head, hit him on his head with a firearm. In his written statement that I now have, doesn't indicate that he heard a gunshot, but didn't know where it was coming from. These are his own words. Didn't know where it was coming from. And then I felt my hands on my neck forcing me out of the backseat of the car. They caught me in front of her sister's house, and Robert Jackson started hitting me multiple times. Oh, he does say multiple times with the gun there, but he didn't say that, so I retract that. But he didn't say that it was Robert Jackson that shot the car. He does say that he hit him with the gun there. But again, and I'll say what I believe. You know, I believe that clearly I don't believe it's Mr. Jackson that was involved. What we have here, and I do believe this came out at the arraignment, is that the young lady who was involved with Mr. Graves, Mr. Jackson and he have a child, the child that he has full custody of. That I believe that he believes, Mr. Graves believes, that the people that are this 11 o'clock at night, he doesn't know Mr. Jackson, but I believe that he believes that these people were sent by Mr. Jackson, whoever injured him. That's what I believe. That's my supposition. I feel that I can make that supposition coming to the court with this valid information that you have, that Mr. Jackson's at his home in Sterling Heights when this is occurring. So again, you know, we have an alibi. I mean, it's a very rare circumstance that you have an alibi even to argue at an arraignment. So
who was the alibi?
That he's at home.
Oh, I thought it was another witness.
No.
But the information that you gave me for the incident. Appreciate that.
Yes.
All right, Mr. Vince, I'm gonna let you go.
Okay, thanks, Judge. And I do appreciate the substance of this. It almost feels like a, you know, quasi-examination, the way that we're doing this, presenting evidence and talking about, you know, issues of fact. Now, I'll tell you what the people believe, Judge. The people believe that this was Mr. Jackson, who was at the scene, who allegedly shot into the vehicle, and then who allegedly pulled him out, maybe with others, but it was Mr. Jackson who ended up hitting them, pistol whipping him multiple times with a gun, and then threatening to kill him. Now, I do appreciate defense counsel is one of the best, and this is what makes this so interesting, because the gravity of these offenses and all of the allegations, I do appreciate him doing a rereading of the statement. There are many consistencies here, Judge. At the time of the investigation with the police officers, it was the complaining witness who specifically said to the police officers, it was Mr. Jackson who ended up doing this. Then he ended up giving a statement subsequent to that preliminary investigation where he identified Mr. Jackson again as the individual who ended up hitting him multiple times with a firearm. Now, I have pictures of the individual as well. Subsequent to this pistol whipping, he ended up having to receive emergency medical. He was busted up. He was busted up. Few things though, Judge, and you know, I just want to get this out. What defense counsel has brought to your honor's attention in terms of this tether information? I believe that is a question of fact, and I believe Mr. Perkins was well within his right. He's doing a great job in including that, but we don't have any foundation for that. I mean, he can give us sheets right now showing potentially that this is the information that accurately represents where this defendant was at the time of this incident. But for all intent and purposes, Judge, we're going to need individuals who are actually monitoring that. I mean, he's going to need to build that foundation up in order for that to be admitted. Now, with all of that being said, Judge, we have a positive ID of this defendant. And ironically, Judge, and I'm sure you read the allegations, we have a complaining witness who is apparently having some type of intimate incident with the mother of the child that this defendant shares with that woman.
And I think that that actually bodes in the defendant's favor. He has custody of the child, remember? So what if the allegations are just that? If it is proven that he was at home on his tethered confinement, I believe charges should be brought against the people filing false reports. If that's the case.
Now, Judge, just based on the allegations, it's the people's representation that this defendant finds out about this, shares a child with the woman that the complaining witness is making out with or making love with or whatever it was, and he ends up allegedly committing these offenses. Subsequent to that, there's some pistol whipping or whatever it was that substantiates the injuries that we all see. We have medical records and so much and so forth. Now, Judge, a few things here that I think the court should take note of. The complaining witness, zero felony convictions. I mean, it's not like this individual is somebody who had a vendetta with this defendant, zero felony convictions. We have a defendant right here who actually has a substantial assaultive past. And now we know he was on federal release of supervision as a direct result of more convictions that he had. Now, in addition to the half, Judge, and I have to make note of this, and I'm sure Mr. Perkins saw this as well. Counts 9 and 10 regarding the weapons felony firearm second offense, those are wrong conviction dates. I don't know how the prosecutor's office got those wrong conviction dates. The correct conviction date is 2012. So maybe that 2012, I don't know, had something to do with this 2012 narcotics case that he ended up picking. 2012 was a bad year for this defendant. Now, with all of that being said, Judge, in addition to the half, I counted 4 other felony convictions. So we have the half 3 plus the 4, we have 7 felony convictions. Complaining witness who has 0, making out, making love with the mother of this defendant who shares a child. And she, Judge, at the time of the investigation, she actually identifies. If you read it, she's the one who identifies to police officers that was Robert Jackson. This Robert Jackson, the man who she shares the child with. Now, conceitedly, on page 3, it says no witnesses were willing to participate, but she was the one who volunteered that information at the time of the investigation. I don't know what she's going to do now, Judge. You can see it. This is a May 7th offense of 2023, and we're before this court right now, some 8-9 months later. I mean, I don't know what was going on, if they were performing investigation. I don't know if they were just trying to get all of their ducks in order, and then they end up authorizing, the complaint. I can't speak to that. What I can speak to, Judge, is we have one positive ID. We have another gal who knows this individual intimately. They had a child together who gave police officers his name. We have an individual who has multiple prior convictions, and we have a complaining witness for all intent and purposes. Why? Why would he have to make this up? Why would he be positively IDing this defendant, but for something which defense counsel hasn't brought to this court's attention up to this point? So, Judge, if it looks like a duck and it smells like a duck, usually it is a duck. Now, I understand this is just redetermination. I've thoroughly enjoyed being able to argue like this because I miss this type of argumentation. I think defense counsel brought up a lot of good points. I wasn't the attorney of record and representing the city at the time of the arraignments. But I do feel as though this should be a level playing field, and I did try to give to defense counsel everything that I had to make this more substantive. I just believe, Judge, just like defense counsel believes in his client, I believe that this defendant ended up committing this crime.
May I respond briefly, Your Honor?
Yes.
Just a couple of things, and it's hard, tough act to follow in that sense of being deferential and accommodating, and he is the individual, brother counsel is the individual that provided me that information at court when we left out. But doesn't come with any necessary animus towards this process. It's just the process. But what I would say is this. One, as it relates to the information that you have, I could show you, that was what reason why being on Zoom would have been a benefit. I could show you the nexus between those statements that I have and the emails that I received from, that would say mi.us courts from Agent Glaros, who is his supervising agent. I think one of the things that I forgot to mention is that this individual, I think the warrant was signed in February 14th of this year. As soon as Mr. Jackson was made aware of it, he surrendered. He found out, they came to his house, I think on Monday or Tuesday. And we found out about it, well, it was Monday, I believe. We found out about it because he was at work. They came to his house. And when he found out about it, he called his agent. I spoke with his agent, who then provided me this information, who, had her own comments about believing in the proof that she's providing me. And I could show you those links to support the documents that you have before you. I think if we were in an evidentiary hearing, that individual would have to come and testify under oath. But the next morning, he surrendered at the DEC because he knows what his position is in this case. He knows that he will be vindicated, or he believes that he'll be vindicated in this matter. And again, my argument today is, Your Honor, it's been 9 months. There's been no other contact or any allegations that this record would reflect that there's been any contact with Mr. Jackson or Mr. Graves, who is the complainant in this particular matter. That's the reason why I would ask that the tether be deleted in this particular matter. And $200,000, when they say it's intentionally meant to be unaffordable, if it stays, then the court's essentially making a determination, I want you to stay in custody. This is an individual who's gainfully employed, who's the sole primary caregiver to the son in common. That woman has not, the complainant or the witness in this case, Ms. Johnson in this case, hasn't come and tried to go through the court to try to take custody of this child or anything like that. So they're all points reflect, I understand what our beliefs are, because this young man, Mr. Graves, who has no criminal history apparently, and I trust what counsel says, just because Mr. Jackson does. That's the reason why I'm not asking, if he didn't have any prior criminal history, I would ask for the cognizance amount, but he does. So, and I have to live with that. And that's the reason why I'm asking for a 10% provision and the removal of the tether, which will allow him to go back to work. He just can't work with Amazon running around with the tether on his leg.
Can I see the statement by the complaining witness? Yes. I mean, it's referenced in both of your arguments, and I'm pretty sure it was not a part of the.
May I approach you?
Yep. And we'll call this
yeah, go ahead. Yes.
People's Exhibit A.
Oh, you're reading that. I'm gonna let the jail, because we don't have anybody else to see. Okay. We're done. Wayne County Jail Division 1, can you go get the officer?
Mr. Vincent, I have in my hand, People's Exhibit, 1. And it's, I guess it's a typed out statement. Is this from Detective Posey?
It appears so, Judge. It appears that this was something that there was dialogue between the detective and the complaining witness that I guess was, and Judge, I printed out just what I had.
Okay.
It appears as though this was what the two had dialogue over. I don't know if it was transcribed as they were going, or if this was something that he was jotting down as the conversation was happening. But as Your Honor can see, I don't believe it's signed either.
Yeah, it's usually,
Right.
this is not usually how we receive a
Right.
witness statement.
Right.
And this is, for purposes in determining bond only, I want to make sure that I'm not, using this for anything other than that.
But Judge, with all candor, I wasn't even relying on that. I believe defense counsel was relying on that due to inconsistencies. But all things being equal, that's not even something that I would attempt to enter as an exhibit. I would rely on the allegations and the investigators.
Okay, give me a second. Okay. I've had a chance to review the investigator's report as well as a statement, some information, at least Detective Posey's notes as it relates to his interview with Mr. Graves, considering the inconsistencies in that report that were argued by Mr. Jackson's attorney, Mr. Perkins. Before me, I have an assault, a very serious assault, where the allegations are someone was removed from the car, someone was beaten by more than one person, and it was eventually shot while trying to flee that situation.
He wasn't shot.
He was not shot,
No,
shot at.
The window was shot.
The window was shot, shot at, excuse me.
Yeah. He was just pissed.
But definitely beaten in those situations. I also have evidence presented by Mr. Jackson, which indicates that there was a felony, strike that there was a monitoring unit at the time of the incident, which would suggest that Mr. Jackson was at another location at the time of the incident. I also have allegations in the investigator's report that the complaining witness, not only indicates who shot him by name, but it also indicates later on that there is a positive ID through a photo lineup. And this is an investigator's report, so it's a summary. I don't know if this was, while he was in the hospital. I don't know why this was, if this was outside or a separate date. I don't have any of that information. I have to just go by what I have. I know that this was a situation where, that happened a number of months ago. But it looks like the warrant was not signed until February of this year. Mr. Perkins indicated that Mr. Jackson turned himself in shortly thereafter, indicated the next morning to address these charges and deal with them as they may. The nature of this offense, the pistol whipping, the shooting at the car, leads me to believe this is a very, very dangerous situation. The idea that people indicated that they know each other, that there are witnesses involved, that however intangible this relationship is, are somehow connected. So I do believe that there is a risk factor as far as the complaining witness and the defendant. However, I would note the time between the date of the offense and when this warrant was signed. I also have to recognize that in the investigator's report, it indicates that none of the witnesses want to come forward. Mr. Vincent, do you have any outside information as to any of these witnesses' availability? Was it just one of the witnesses or was it all of the witnesses?
Judge, the most pertinent being, I think, the mother of the child had shared with the defendant who was with the complaining witness at the time. I took the investigator's report as her being a witness and her being one of those witnesses guised in that group that wasn't willing to come forward. Now, that was at the time of that, so I don't know if anything's changed since then, but I think right now what the people are relying on would be the complaining witness if taking that statement in the investigator's report as being true.
Yeah, my question is, does that statement as it's written include the complaining witness?
I don't believe so, Judge. I believe the complaining witness to be more in this instance, the victim, because he actually did speak with police officers subsequent to this offense. So I wouldn't put him in, because remember, Judge, in the allegations, there was an individual that they spoke to that was walking around the apartment building. He did not want to be a part of this. The mother or the individual that was with the complaining witness witnessed this, but wasn't involved in the actual incident regarding subsequent charges. Now, Your Honor may have a different take, and I completely would respect Your Honor in terms of that. The people see it differently. The people see the complaining witness as the victim.
This is one of the reasons why I asked for the witness statement, because I wanted to see a timeline between, time of the incident, maybe at the hospital where you can't move versus coming into a police station and then making that second determination.
And I actually, Judge, and I kind of anticipated you going that route. So while you were talking about the different arguments that Mr. Perkins and I was exhausting you with, I went into Carpel and looking for that being transcribed into a formal statement where it would be signed. There's nothing. That's it.
No, I even outside of the statement, just a different date,
right,
anything else.
I don't have anything else.
Okay. Mr. Perkins, I'm in partial agreement with you. I do believe that the bond is too high. It essentially is a remand, and I'm going to lower the bond to $20,000, strike that $200,000, 10%, but I am going to order a GPS tether while this matter is pending for the safety of the complaining witness, Mr. Graves. If this matter is going to resolve itself, I want to make sure that there's some sort of monitoring while this takes place. The allegations are disturbing. Somebody removed from a car, pistol whip, and then that car shot at. You indicated that the complaining witness wasn't shot. Well, somebody actually shot at that car, so I don't know what the intention was. And I do believe that, some sort of monitoring is necessary for the protection of the community. So I'm going to adjust the bond to $200,000, 10%, with a GPS tether while this matter is pending. I want to know where the defendant is while this case is.
There's no restrictions other than just the monitoring.
I just need the monitorization.
Let me put on the order, because what happens if you don't put that?
We'll put it on the order.
She already knows.
But I have to say this, there's no contact with the complaining witness, Mr. Graves, while this matter is pending. And I'm going to put no contact with Kim Gardens while this matter is pending. I don't know what's going on there, but while this is pending, Mr. Jackson, you can't be there. Do you understand?
Yes.
No weapons while this matter is pending as well. Mr. Perkins, Mr. Vincent, is there anything further?
We retain the date for March 14th.
March 14th date stays, and that's going to be before Judge, Jefferson.
Okay. I just wanted I appreciate you hearing the people out, Judge. This was an elevated redetermination. I think it was only because of Mr. Perkins' status in the community that I felt like I had to match his absolute intelligence and wit. So I appreciate you hearing us out.
Well, I really don't know if anybody's going to match Attorney Perkins' elevated wit, but Mr. Vincent, you did a great job.
Thank you so much.
All right, good to see you both. And that concludes the hearing. Oh, Mr. Perkins, these are your exhibits. And Mr.
Wayne County Division 1, sir, what's your name?
Robert Jackson.
No, you all said, Mr. Jackson, we got
Okay,
you.
okay, all right.
Can you give that to Mr. Vincent?
Can you get the officer?
Terry John, officer,
Okay, we don't have you today.
Terry Jones.
No, we don't have a Terry Jones for today.
When you got Terry Williams here, I got a lot of AKAs, so which one? You got Terry Shepherd, Terry Williams. I know I'm supposed to go to court today.
Okay, I think you're in the wrong courtroom. Can you get the officer for me?
Officer.
Hey, no sweat, man. What's that? I'm gonna be in my chambers, going back and forth between chambers and courtroom.
Okay.
So he's got a lot of AKAs, is what he said.
Send them down to the courtroom. I'll be down there in a little bit. Okay. Oh, can I have one of your peanuts? Mr. Vincent, how you doing?
Good morning,
You know, just working,
Yeah, fair enough.
just grinding.
Wayne County.
These, if you really take these seriously, they're substantial. So,
I can't hear you. Could you move over some so I can see? Because I can't really hear you.
yeah, I can help you with that.
If I take one of these whole things.
Go ahead, because I take it all the way down to there.
I
Okay?
don't need them. I don't need them. These right here, I'm leaving. See ya.
All right. Did we just read?
Okay.
Okay, and one of them just bring them out.
Can I get the defendant's name? I believe he's in the wrong courtroom.
We have him booked in under Terry Jones. He have multiple aliases. Another name will be Terry Williams.
No, Terry Shepherd.
I'll do Jones, you can really.
Oh, I remember the shepherd.
Okay.
Yeah, because
S.H.
Shepherd's my real name.
Okay, S-H-E, how you spelling shepherd?
SHEPARD. That's my real name. Now I got my state ID with my real name. It's
Okay,
Jones'
okay,
name.
okay,
Came from a misdemeanor.
okay, okay.
Okay, it's not Jones because he has a pre-trial 4-9 that.
Yeah, my real name is Terry Shepherd.
What's your middle name?
Versus my.
Ray, R-A-Y. All of them got 5/12/1956.
Okay.
He's 70 years old, and I want to get the hell out of here.
Okay.
He's making me miss days. These days. You know my real name. Keep putting up all this other.
He's supposed to be in Ravens.
Say what?
I think he's supposed to be down in Ravens, but, okay, so he's got an ongoing case over in Frank Park.
Oh. Shit. I'm physically hurt too.
So we got Terry Jones, Terry Shepherd, and what's the other name?
Terry Williams. That was the name I was going, that's my real name too. My mother didn't marry my.
Okay.
So I got my mother's maiden name, Terry Shepherd. That's my real name. It's on my state ID, Michigan state ID. I'm not going to keep coming up with all this old shit.
Okay, so we got.
Making me miss sports dates.
Okay, Terry.
I see a habeas that was not entered for Shepherd. But it doesn't give us an arraignment date.
No.
Case would have been dismissed yesterday. If I knew it was my court date.
Oh, your court date was yesterday.
Oh, your court date was yesterday?
Yesterday, yeah. I was on the tether. I was at the house. I can't talk.
No, you don't want to say too much. We just need your name and the court date.
When they need my tether address as well, it's the same address. I turned myself.
Okay, well, I had that cape, so that may be it.
Where's the sheriff again? Where's the lady?
I didn't hear you.
Where's the
Yes,
lady?
Oh,
Do you have a CTN number?
One moment.
same address, 66 Hingham.
No.
She give me the CTN number. Right?
Yeah.
Let me know when you're ready.
I'm ready.
82, 23,
Okay,
71,
okay.
00, 13,
Okay.
01.
All right.
When you got to go to the numbers, the identification numbers of the cases, because the defendant has too many names that you can't identify him. And he is such a treat.
Let's see. Oh, it's up Terry. Wait a minute. He's scheduled for arraignment. It was today. He should be downstairs in 133. 134. What is it? What's the arraignment?
134.
134. So zoom into 134. He's scheduled for a first-degree home invasion and arraignment today.
Okay, thank you.
Get used to going downstairs, sir. Because I have a feeling, I mean, you're 70. Yeah, you may have another 10, 15 years on you, but I have a feeling downstairs is where you're going to find yourself.
You're welcome.
You beat me to that.
Good to see you.
Man,
It does get to see
just
you.
getting beat all over the place.
See you, Maya.
Bye, Marcia. Bye, Steve.
Bye, Maya. All right, we'll see you tomorrow.
I just love Vincent. He's so funny. I'll see you tomorrow. Yep. I always enjoy Mechanico's courtroom because there's just that loving banter. You know, I mean, when they're not actively working, they are just they're buddy-ish. But you put them, you know, where they have to argue against each other, and it's just comedic gold. I told you before you started to go to bed. That's on you. You're the stubborn one that wouldn't listen to me. Oh, well, you have a good night, Philippines. Everybody's nodding off, I guess. But that's okay. That's all right. We'll still be here for you guys. Love you. All right. Now, the audio quality of this one is terrible. In as far as like the judge, he's wherever he's at, it just sucks. But man, he's a cranky man.
Anything you want to say? Mr. DeMambro, anything you want to say? Can't hear you, Mr. DeMambro. Turn up your volume and speak into the microphone.
Yes, Your Honor. Can you hear me now?
Yes.
Okay. I would like to sincerely apologize to the court and the city of Mount Clemens for any trouble that I have caused. I would like to thank my lawyer, Ms. Cynthia, and my probation officer, actually, Ms. Chelsea, whose essential counsel has been very motivating through all of this.
What are the
That's it for now.
guidelines, Mr. Rapsky?
0 to 3, Your Honor.
All right. It is the sentence of the court that you be placed on probation for a period of 2 years. On each of your 2 counts, I'll order that you serve 2 days in Macomb County Jail. Credit for 2 days' time served. Those are concurrent with each other. You're to complete the Class A Training Center program on impulse control, not use drugs or alcohol, seek and maintain employment of at least 30 hours per week. You're to pay a $68 and a $50 state cost, $130 crime victims' rights assessment, supervision fee of $30 per month, court costs of $900. Is there any restitution in this file?
Yes, Your Honor. Restitution.
Mr. Sorrentino?
$2,179 payable to U-Haul.
I'll order that as well. Sir, if at any time your probation, you can pay all your fines, costs, and restitution, and an additional $1,200 in court costs. I would discharge you from probation at that time. So you can be on probation for as little as 1 day. Sir, you're entitled as a matter of constitutional right to file an application for leave to appeal your conviction and sentence if you're financially unable to provide counsel to perfect such appeal. This court will appoint counsel for you. Request for assistance of counsel must be made within 42 days. Supreme Court change that to 6 months. You're to get assigned advice of rights to the court. Counsel, purpose of my sentence.
Judge, 7411 granted on count 2.
Yes.
And Judge, the people move to dismiss count 1 pursuant to the plea agreement.
No objection.
Granted.
And Your Honor, if we could add possible to add a condition, no contact with U-Haul and all the victim on the case.
Yes.
Thank you.
Thank you, Your Honor.
You're welcome.
Your Honor. Thank you.
That's actually a pretty darn good deal. You're on probation until you pay the restitution and all the court fines and everything else. And then you're not on probation anymore. So if he had the money or if he could get it from family and friends or whatever, he could be off probation real quick. The judge is not interested in punishing him or monitoring him or anything. He wants U-Haul to get paid back for the damages. That's pretty much just it. And I'm sorry, but did you catch that big F you from the judge? I bet that boy worked real hard on that speech. He was reading it and going along with all his thank yous and apologies, and the judge just cut him off. Judge is like, I don't care. Whatever. This is a canned speech. I've heard it 1,000 times. You're not really sorry. Let's move on.
Thank you.
The court called People versus Alford, date and time for sentencing.
Anthony Sorrentino on behalf of People.
Derek Wilczynski on behalf of the defendant, Faith Alford. Judge, I have reviewed the pre-sentence report with Miss Alford. I've emailed and texted copies to her. She indicates there's no additions, deletions, corrections, or modifications. From my review of it, it looks to be accurate as well. We are ready to proceed to sentencing.
Your client waives their right to be physically present in court.
That's correct, Judge.
All right. Anything you want to say on her behalf?
Yeah, I do, Judge. Miss Alford has 2 children. She's also receiving SSI. She has a learning disability. She indicated to me that she learns at a slow rate. I think, Judge, she got taken advantage of by the co-defendant in this case, as well as other people she was hanging out with. Quite frankly, she needs to clean things up in her life and get back on track in terms of, well, quite frankly, not committing these offenses. Her criminal history isn't terrible. She has 2 priors, I believe. This is well, actually, let me double check because it's either 2 or 3, but not terrible. My concern for her and what I've been trying to help her with is she needs to get these warrants taken care of, a lot of driving charges. But I think the recommendation is fair and it fits right into what we had discussed, Mr. Sorrentino and I. 11 months probation seems to be reasonable. She understands too, she's going to have to pay restitution as well. We have no objection to that, $630.
All right. Guidelines, Mr. Repsky.
0 to 6, Your Honor.
Those appear to be accurate
All
as
right.
well, Judge. No
At
objection.
every criminal sentencing, Mr. Rapsky, would you be so kind as to announce the guidelines before we start?
Yes, Your Honor.
All right, very good. Ms. Alford, do you have anything to say?
Yes.
Ms. Alford, do you want to say anything?
Yes. I'm sorry, Your Honor. I was hanging around the wrong people at the wrong time. I got me a house, a car. I'm trying to find me a job. I'm trying to better myself for my kids and stay out of trouble.
All right, ma'am. I'm going to need a review date exact in 1 year. It is a sentence of the court, ma'am, that you be placed on probation for a period of 1 year. File order that you might use drugs or alcohol, seek and maintain employment of at least 30 hours per week. You're to serve 4 days in Macomb County Jail, credit for 4 days time served. Complete the Class A Training Center program on impulse control. You're to pay a $68 state cost, $130 crime victims' rights assessment, supervision fee of $30 per month, court costs of $900. Any restitution, Mr. Sorrentino?
$630 payable to Alta.
Okay, I'll order that as well. Ma'am, you're entitled as a matter of constitutional right, file an application for leave to appeal. It's actually 771, no appellate rights.
We just need that review date, Judge.
Yep.
The review will be February 27th at 9:30.
And Judge, no contact with Alta.
Yes.
Defense agrees, Judge.
All right. You have your criminal hat on today, Mr. Wilshinsky, I see.
I do. You've been used to seeing me with the civil hat. It's good to change every so often.
There you go.
Judge, I forgot that the appellate rights didn't have to be filed in this, and I actually did file them this morning. So I'm letting Zach know that you can just reject the filing. I was trying to get a jump on it.
Thank you.
All right, thanks, Zach.
Thorough as always, Mr. Wilshinsky.
Thank you, Judge. Have a great day.
Thank you,
Zach.
Thank you. The court can call People versus Jones, date and time for sentencing.
Anthony Sorrentino, appearing on behalf of the people.
Your Honor, good morning. Josh Jones appearing on behalf of Mr. Jones, who is available on Zoom and waiving his physical appearance for this hearing, Your Honor.
Judge, we could do this on the record or do a breakout room.
Wait, Jones representing Jones? And wasn't Jones one of the aliases of the last guy? Like, is that a theme tonight?
Mr. Jones sent me a letter Mr. Jones. Mr. Jones sent me a letter regarding his client, Mr. Jones. I'll let him elaborate a little bit on what's going on.
Your Honor, if the court recalls, Mr. Jones was previously at Henry Ford due to an assault on him where he received a subdural hematoma or hemorrhage, and has also had multiple fractures on his body and left him in a state where he is going to be bedridden for essentially the rest of his life. Within the last week, he had been readmitted to the ICU after going into a nursing home where he's going to be spending his last days. He is now back in the nursing home after spending a week in the ICU.
Spending his last days, does he have a terminal diagnosis?
No, Your Honor, his health is deteriorating rapidly, is why I say his last days. When speaking with his wife, who's assisting him for the Zoom call, she's indicating that cognitively he's cognitively declining. He is bedridden. He is on a feeding tube in order to have to live or to get substance. And then he's also essentially on any assistance to go to the bathroom. He recently had a low blood count, which left him anemic.
Mr. Repsky, guidelines.
0 to 11.
Judge, the bottom line is he might not understand what's going on. As far as.
Well, you know what, here, I'm gonna adjourn the sentencing. Give me a new date in April. I need all that in a letter from a doctor or copies of his hospital records. I'm not going to just accept that on faith.
I understand that, Your Honor. I will coordinate that so that the court has it well before the hearing, so that the court can review it prior to the sentencing date.
That would be great. New date.
April 18th at 9:30.
Thank you, Judge.
The court can call
You're all
people.
set, Ms. Jones. You can sign out.
Court can call People versus Gonzalez, date and time for a motion for permission to leave the state.
Appearance.
Anthony Sorrentino on behalf of the people.
William Brady, I'm appearing on behalf of Lori Gonzalez, seated to my right, who waives the right to be physically present at the court. Your Honor, this is our motion, Your Honor, for Ms. Gonzalez to have permission to leave the state of Michigan for employment training from the dates of March 17th in the evening after she's released from the Macomb County Jail and continuing till March 22nd, 2024, which is a Friday. And at that time at 7 o'clock, she will be continue to serve her 3-day weekends as part of her sentence. She's working in the auto and food industry, beverage industry, and creating and selling sensors. And so periodically, at least twice a year, she has to be trained. And she would like the court's permission to attend that training at that period in Florence, Kentucky, which is across from Cincinnati, Ohio, about a 5.5-hour drive. And I have a proposed order that would allow her to, with the okay of her probation officer, to attend additional training during her 2 years of probation, if that's agreed to by the court. I believe Mr. Sorrentino indicated he has no objection.
What do you mean, counsel? You mean a blanket order? She can go whatever she wants?
It would have to be approved by her probation officer, Your Honor. But if Your Honor is not inclined to give that.
Did you attach that? Yeah, I see the order attached to your motion. Hold on, let me see what it says.
Sure.
Judge, I mean, obviously it's the discretion of the court. I don't really have a objection. I guess maybe if you would like, you could do if you're inclined to grant it, you could do an ETG test upon her return or something of that nature, just to make sure she's not drinking. And I guess since it's a OWI 3rd, she probably doesn't have a driver's license, so I don't think she should be driving. But
I'd like to speak to that, Your Honor. She does have.
I mean, as I view this request, it doesn't really interfere with any testing that she might be doing. So I don't see the need for an ETG. Your motion's granted, but all travel has to be pre-approved by patient. Given the entry of this order, you don't need to come before the court. Just run it by probation.
Very well.
Thank you, Your Honor.
You're welcome.
Deputy at the jail.
Did you say she does have a license, Mr. Brady?
Yes, she does. She does
Mr.
have a
Rapsky,
restricted
how's that
license.
possible?
Okay, we went through this before, but her last.
We did this at sentencing, actually. I recall it now.
Okay.
Her convictions were older. Is that right, Mr. Brady?
I'm sorry, I didn't hear the last sentence.
I said we did do this at sentencing. I believe you indicated her convictions were older and
correct. Over 10 years old. That's correct, Your Honor.
All right.
Ooh, that prosecutor got mad there for a second. He was not having that at first.
Very good. Next case.
Deputy, can we have Prantera, please?
Yes, good morning. Good morning, Your Honor. Prantera.
What's the name?
Prantera, Judge, this is one of our pickups this morning. Diane sent you the email at 9:06.
I need to know that before I waste time looking for a file.
My apologies, Judge.
No problem.
The court can call People versus Prantera, date and time for a probation violation arraignment.
Yes, good morning.
Yes, good morning, Your Honor. For the record, Attorney Stephen Becker appearing on behalf of the Macomb County Defender's Office for the purpose of arraignment only. We waive from our appearance to enter plea not guilty, stay mute, ask for court-appointed counsel.
Did you apprise your client of the nature of the warrant, counsel? Mr. Becker, I ask you a question.
I'm sorry, Your Honor, you were cutting out.
I said, did you apprise your client of the nature of the warrant?
Yes, I did, Your Honor.
Zach, can you hear me?
Now I can, Judge.
Mr. Becker, can you hear me?
I can now, Your Honor. You were cutting out for some reason. I did
Did you
apprise my
your
client.
client of the nature of
Yes.
the warrant?
Yes.
All right, that email hasn't downloaded, so read it, Zach.
Yes, Judge.
Read the allegations.
The allegation is contrary to Rule 3, the defendant failed to the probation department as directed. He failed to report on February 6, 2024. The defendant's whereabouts are unknown at this time, and due to the defendant having a history of controlled substance abuse, he may be a danger to himself and or the community. And that is all.
I'm sorry,
Zach,
Judge.
you hear me?
Back and forth, Judge. It's kind of cutting in and out.
Zach.
Yes, Judge.
Do you have my file there?
I do have the file.
Look at PSI. What's his record in terms of felonies, misdemeanors?
He has 6 felonies and 9 misdemeanors, Judge.
And any prior probation violations?
There are no former pending violations.
Your Honor, if I may, he did have one prior violation. Essentially, it was for the same thing. He absconded back September of 23.
And then he absconded again. All right, I'll set his bond at 25,000 cash surety or 10%. I'll make a condition that he be hooked up to other GPS with the Smart Start company. We've entered a plea of not guilty. The
probation violation hearing will be March 14th at 9:30.
Thank you, Your Honor.
Okay, March 14th?
Yes.
Okay, thanks.
Mr. Prantera, you can let them know behind you. You're all set.
Sure.
Oh, goodness, that was fun. That guy was cranky. Oh, my goodness. That hearing came from February 27th. I meant to click the March 7th folder, and for some reason it clicked on that one, and I didn't notice until he set that hearing a year out. And then I was like, 1 year out, February 27th, that's a different date than I thought I was on. But the folders, for some reason, they were one right on top of the other. So that's what did it. I have 7 minutes, y'all. Well, 6 minutes and 40 seconds until I hit the 2 hours. So I don't have a clip that short. So we are going to have to entertain ourselves for 6 minutes and 20 seconds as of now. I think we can do it. I think we can do it because I'm pretty sure if I were to ask her very nicely, Ava would wake up from her nap and come over here and get treats. Ava would wake up from her nap and come get treats. Ava. 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 Hey. Hey, sleepyhead. Come get treats. Ava. squeaky cheese. I'm from Wisconsin. Squeaky cheese is the best. We have it all the time. No, she would much rather have a pepperoni stick. Did you see that head perk up? I said pepperoni stick. Oh, you got no wrong side, baby girl. Wrong side. You gotta come over this side. Over this side. Come on, good girl. Oof, wait. Be gentle. Good girl. Wait, good girl. Be gentle. Be gentle, good girl. Yeah, you'll get it, I promise. No one else wants it. No one else wants it. You're the only one who's going to eat it. I promise. It's all yours. Good girl. She's such a pretty girl. Wazoo. I've never heard of that. Is that a type of cheese? Or, I mean, it sounds like a parade festival. But I've never heard of that. What's up, girl? What's up, baby girl? I love you. Much love. Much love. Yeah. We got our Ava. Now y'all got your Ava time. Yeah. Oh, interesting. Cougar Gold. I've been called that once or twice. Gouda's pretty good. I like Havarti. And White American is probably my favorite. Like, Land O'Lakes White American is so good. It's salty and creamy and smooth. It's really good. But you got to get it from the deli. You can't buy it on the shelf. When it's from the shelf, it's like plastic. But yeah, we have cheese curds here all the time. Like, we have deep fried cheese curds too. Like, those are amazing. They're sold everywhere. That's cute, Salty. That is cute. Salty wins. Salty wins the comments tonight. Yeah. That's exactly it. She just wanted that pepperoni stick, and now she's done until I crawl into bed, which is going to be in 1 minute and 36 seconds. I have never heard of that one. I've heard of Old English. It comes in a little glass jar with a metal lid on it. Yep. And it's like a processed cheese almost, I want to say. It reminds me of years ago, they and I don't even think you can get them anymore. Around Christmas time, you could go to Walmart or grocery store or whatever and buy these kits, like they sell at Christmas. But it would have a wheel of cheese wedges wrapped in like aluminum foil, like little aluminum foil type wrapping. And then you just, pull the little red piece and then unpeel the wedge. And they were so good. It was like a whole bunch of those something cow. Laughing cow cheeses. It was like a whole bunch of those, but of all different flavors. And Old English actually tastes like this cheese did, like from the Christmas wedges. Humboldt Fog. I've never heard of it. Yes, it is. Right? Well, we're gearing up for a fondue party. That's all. Yep. Tomorrow it'll be chocolates, and then the next day we'll go into what else is good with fondue? Yep. Yeah, it was very similar to that. Kendra really likes, there's a certain wine flavor that she likes. It's not port wine, but it's one of the other ones that you can get. All right, guys. I'm now over my time that I was trying to reach, and I'm super tired, so I'm going to go to bed. I love you all. Thank you for coming and hanging out with me. Be safe, be well, sleep sweet, and much love.